thought you would appreciate having 10 more minutes. Thank you. Mr. Anway on jurisdiction.
Ms. Polikova is lead counsel for the Slovak Republic for closing argument. Mr. Chair.
You were impatient to hear her.
That's the debt from Monday. Dear members of the tribunal, on behalf of the Slovak Republic, I would first of all like to thank you for your time and attention this week to the Slovak Republic's arguments, as well as to your willingness to learn this lovely Slovak word, dobývanie. During this week, we showed that claimants' claims are tainted by a number of defects on jurisdiction, and that's why they should be dismissed in the first place. But we also showed that independently of those defects, the reassignment was correct, because Rozmin did not even come close to carrying out dobývanie in the 3-year period required by Slovak mandatory law, the 2002 amendment. In line with the tribunal's instruction, the Slovak Republic's closing statement will be dedicated to the main legal issues as they have crystallized this week, without commenting really on the hearing as such. We will start the Slovak Republic's closing statement with my colleague Steve Anway, who will address jurisdictional matters. He will first show that Belmont does not own the protected investment because it does not own the 57% interest in Rozmin, and then he will show that EuroGas too does not own the 33% interest in Rozmin. We will then leave the floor to claimant's closing statement on jurisdiction and merits, and following which the Slovak Republic's closing statement will proceed also on the merits. Thank you.
Thank you, Mr. Chairman. Rest assured you'll hear more from Ms. Polikova later on the merits section on her law.
It has been promised.
It has been promised. As Ms. Polikova indicated, I will address jurisdiction first. We will not get into the merits during this presentation. We will, of course, later today as we conclude the hearing. And I will present the jurisdictional arguments in reverse order. First, we're going to deal with the jurisdictional objection with regard to Belmont, and then we will deal with the jurisdictional objection with regard to EuroGas 2. We do so because chronologically, at least, that is more appropriate given that Belmont sold the 57% in 2001, which meant that when EuroGas 1 entered bankruptcy, it had the full 90%, the 57% that Belmont transferred to it, and it held that interest directly, as well as the 33%, which it held indirectly through EuroGas GmbH for the full 90%. And as we will show, when that interest went into bankruptcy, it never came out again. Let's start with Belmont. The tribunal will recall that there are two separate jurisdictional objections we have raised with respect to Belmont. The second one that I described on Monday was that the Canadian treaty only started to apply in 2009, and Belmont's claims therefore fall outside this tribunal's jurisdiction rationality temporis. That jurisdictional objection received little attention after our opening statement this week, and given how little time we have today and how much ground we have to cover, I will not be discussing that jurisdictional objection. But I want to emphasize how crucially important it is to the tribunal's jurisdiction if the tribunal makes it that far in the analysis. That is, if the tribunal can get past the other jurisdictional objections we'll discuss today. So with that said, I'm going to focus the remainder of my time on the 57% interest in its transfer to EuroGas 1. Now, particularly given the evidence that emerged at the hearing this week in support of this objection, I'd like to pause at the outset and ask you to bear something in mind during my entire presentation, particularly with respect to the Belmont issue. It is the claimants that bear the burden of establishing the facts necessary for your jurisdiction. It is not the Slovak Republic's burden to show that the tribunal does not have jurisdiction. It is the claimants that bear the burden to establish the facts necessary for the tribunal's jurisdiction. And that burden is particularly important on the Belmont issue. Now, based on all the evidence you saw during our opening statement, you'll recall I put up quote after quote from representatives of both Belmont and EuroGas, and those two companies in their financial statements. Statements to the police under oath. Statements to prospective third-party purchasers. They described their deal as a sale that had been completed and that Belmont retained the shares as a collateral interest only. And of course, you saw Mr. Anderson's cross-examination yesterday. In view of those facts and Mr. Anderson's cross-examination, we don't think there is any conceivable way one could argue that the claimants have carried their burden of proof. Indeed, as I noted, we showed you on Monday all of those different statements that representatives of Belmont and EuroGas made, and in particular, I directed you to sworn testimony that Mr. Robal and Mr. Agiagos made to the Slovak police in 2009. If we go to this slide, which is slide 5, this again is a slide I showed you on Monday, and it is an excerpt from a witness statement that Mr. Agiagos gave to the Slovak police. He stated, with regard to the fact that Belmont Vancouver sold its business share around 2002 to company EuroGas, we did not incur direct damage, and we show you his signature there. On the next slide, you'll see that during the hearing this week, under cross-examination, Mr. Agiagos confirmed that he did in fact make that statement, and that is his signature. Mr. Alexander asked him, did you make that statement under oath? Yes, I made that statement. Did you make that statement under oath to the Slovak police, yes or no? Yes. If we go to the next slide, you'll see that Mr. Alexander continued, but there's no doubt in your mind you made this statement under oath to the police. Yes, yes, that is no doubt. And as I showed you on Monday, there are criminal penalties for untruthful evidence provided to the police. On the next slide, we'll see that Mr. Robal gave a similar statement to the Slovak police. Rosman, he stated, quote, is a company in which EuroGas GmbH holds the 33% of the shares, and American EuroGas Inc. holds the 57% of the shares, thus together holding 90%. And you'll see his signature at the bottom. On the next slide, Mr. Robal, during cross-examination, also admitted that he too provided this testimony, and that is his signature. Mr. Alexander asked him, did you make that statement to the criminal authorities when you were under oath? I did. You took seriously the responsibility to tell the truth that day, didn't you, sir? Well, I was of the opinion that this statement was correct at the time. We go to the next slide. Mr. Alexander continued, I assume, just in the interest of time, that you also authorized the next paragraph. This was a different statement that was made in a different document. EuroGas, quote, expressly confirmed the rightful title of the EuroGas GmbH to the 57% business shares of the company Rosman. Yes. And before I go on, let me remind you, this is the document in 2012 that EuroGas AG made to the German stock market. And this is the document that shows that the 57% was not just transferred from Belmont to EuroGas in 2001, but that EuroGas then transferred the 57% onto a third party, EuroGas GmbH. And this is the document that shows it to be so. And then Mr. Alexander asked Mr. Robal under cross-examination, so you thought it was true at the time you signed it? And he answered, at the time I signed it, yes. Next slide. The final paragraph in that public statement, quote, EuroGas AG thereby directly or indirectly holds 90% of the Slovak mining company Rosman. Does all your prior testimony about the procedures that were involved apply to this paragraph as well? Answer, that's correct. Now, members of the tribunal, you saw the cross-examination of Mr. Anderson yesterday. Candidly, I have not included slides of Mr. Anderson's testimony because there are too many. If I could put his entire cross-examination on a slide, I would. He was crystal clear that he, even not relying on the public statements I just showed you, looking at the four corners of the document, the SPA, concluded that it transferred the rights to the 57%, and that the 57% shares were simply held as a collateral measure only, as a security interest, as a pledge. Here, I asked him, if you did look at any documentary evidence, which documents would you find most instructive or important on the issue? And Mr. Anderson replied, I think the two principal and most reliable documents, this is on slide 12, from an evidentiary perspective under Canadian law are those that are most contemporaneous with the transaction. So to me, the two documents that best represent and are most helpful in interpreting the contract are the information circular that was prepared on June 8th. Let me stop there. That's the document that Belmont circulated to its shareholders because it needed approval for the agreement before it proceeded with it. Remember, as a 57% interest in Rosman, it was a controlling share in the company. And therefore, Belmont had to obtain approval from its shareholders before it could enter into that agreement. The circular, which is what we call that document, is what was sent to the shareholders to sell them on the deal. That's the first document. And the second, and I'll just paraphrase, are the financial statements. If we go to the next slide, I'm going to show you each of these two documents just by review. This is the circular, and as Mr. Anderson explained to you yesterday, he was focused in particular on the word guarantee and how it was described to the shareholders as a guarantee. This again is consistent with the notion of the collateral, the security interest. And then if we go to the next slide, the other document he found most important were the financial statements, and in particular the first financial statements filed after the SPA was entered. Those are the audited and consolidated financial statements for the years ending January 1st, 2002. Now, during my redirect of Mr. Anderson yesterday, we went to these two documents. We spent a little bit of time going through them, and I've highlighted for you up on this slide the key portions that I took you to yesterday. You'll see that in the very first quote, Belmont stated in its financial statements, and let me stress, these are audited financial statements. It is difficult to imagine a more authoritative document in the corporate world than financial statements because they carry with them potential criminal liability for any statements that are not true. In this financial statement, speaking to investors, the company said, the company, Belmont, sold its 57% interest in Rosman effective March 27, 2001. The accounts and operations of Rosman have been consolidated in accounts up to the date of disposition. That means prior to this sale, Mr. Alexander went through this with Mr. Adiagos on his cross-examination. Prior to the sale, Belmont had consolidated Rosman. After this sale, as you can see from the next sentence, the company has recorded the EuroGas transaction as a sale, as a completed sale, and disposition of a subsidiary, and holds the shares as a collateral measure only. In other words, it's disposing of the subsidiary now. It's no longer consolidated within Belmont after this purchase is made. And then in the notes that we saw at the end of the day yesterday, we highlighted a few items here. These, if you look at Article 2 of the SPA, there are 5 conditions preceding listed there. These are 2 of them that shows they were satisfied. One is the transfer of the 12 million shares of EuroGas. The other is the payment of what was called the non-refundable advance royalty of €100,000. The other 3, you'll notice, all use the word hereby in the SPA, and therefore mean condition preceding is simply granting the right to receive royalties in the future and similar other rights. That's the financial statement, the very first financial statement filed after that 2001 SPA between Belmont and EuroGas. Now, we also think it's important that during their cross-examinations, Mr. Adiagos and Mr. Robal acknowledged and understood how important it was to be accurate in these financial statements. Mr. Alexander asked Mr. Adiagos, who was responsible for the financial statement we just saw, quote, did you take the filing of financial statements to be a serious undertaking? Yes, yes. Question, in Canada, are there criminal penalties for filing false financial statements? Answer, yes. Next slide. This too is with Mr. Adiagos, and you can see at the bottom of each slide we indicate who we're quoting. Question, given your own characterization of yourself as the finance guy, you obviously reviewed these being the financial statements, before they were filed? Answer, yes, I do. Question, and you wanted to ensure they were accurate? Answer, correct. Question, because as we said, it's a serious undertaking, yes? Answer, yes. Mr. Alexander then went on. Question, are you telling the tribunal that your financial statements are inaccurate? He said, no, I'm not. Question, I didn't think so. Answer, no, I'm not. I'm not. And again to Mr. Adiagos, question, as an experienced businessman, would you agree that's a pretty serious thing to file a financial statement? Answer, that's right. Indeed, Mr. Anderson noted when I asked him, have you seen statements from the parties characterizing their deal? He said, yes. I said, did you consider them to be consistent statements? And this was his answer. Effectively, he found that things seemed to change around the 2005 time period, that the statements became more inconsistent after 2005. Mr. Chairman, I would suggest to you and members of the tribunal that that is not coincidentally around the time of the bankruptcy, when EuroGas had an incentive for the trustee not to believe that they owned the 57%. Prior to that time, the public comments that both parties made were more consistent and described the transaction as a completed sale and only a retention of a security interest. Indeed, counsel for claimants put up and presented to a witness testimony from Mr. Blankenstein from that bankruptcy, where Mr. Blankenstein specifically stated that they didn't own the 57%. And again, there was an incentive at that time to make the trustee believe that the deal had not occurred. And that's when the statements became contradictory. Next slide. Okay. Now, claimant's counsel had suggested to you in the opening statement on Monday that in fact this deal could not have gone through because EuroGas 1 was a dissolved company at that time. As I hope came through clearly from the witness examinations, in fact, the contract that is undisputed was signed before EuroGas 1 became a dissolved entity under Utah law. The contract was signed in March. It did not become dissolved until July. Mr. Garabi then put to Mr. Gardner, our Utah law expert that you saw yesterday, you were able to measure his credibility, whether the deal could have closed, that if it closed after the company was dissolved, but it was signed before the company was dissolved, whether that could still lead to a valid transaction. And Mr. Gardner opined that it could, that the sale could be completed, notwithstanding the fact that the closure happened after it being dissolved, because it was signed before it was dissolved. And his explanation was the following. Quote, I think it could do that. In other words, it could still close that transaction because subsection C of 14051 says a permitted action after dissolution is, quote, discharging or making provision for discharging liabilities. I view that to contemplate performing obligations. Go to the next slide. Under a contract. So even if the contract entered into prior to dissolution involves the acquisition of an asset, still the company is bound by that contract. It signed it before it was dissolved. It has a duty to perform, and the statute permits, quote, the discharge or making provision for discharging liabilities. And I view liabilities to include contractual obligations. As it moves forward toward liquidation and winding up, it has to take care of its obligations, and one of them is to close the transaction it previously agreed to enter into. And Mr. Garabi asked him, but what about if the closure date has not arrived even? And Mr. Gardner says nothing changes in the analysis I just stated. The closure date is when it is. Next slide. Now, Mr. Gardner also brought to your attention yesterday a brand new case that had been issued after all of the expert reports had been issued in this case, and in fact has just been issued this month in Utah, which he later stated he believes reinforces his ultimate conclusions in his report rather than weakens them, and I'll come to why that is. It relates to the EuroGas objection. I won't address that now. But I do want to address a suggestion that was made during his cross-examination that somehow that case could in fact help claimants. And the basic suggestion was that this new case makes contracts entered into by dissolved companies after the 2-year reinstatement period has expired void. Not voidable, but void. Now again, that has serious implications for EuroGas's jurisdictional standing. But for Belmont, it doesn't. Why not? Well, as I hope it came through during my redirect of Mr. Gardner, our case is different in 2 important respects from the new case. The new case, as I said, involved a situation where the contract was signed after the company had been dissolved and after the 2-year reinstatement period was over. Neither is the case here. Neither is the case here. And I just put these slides up for you to note the difference here. One involved a situation where the contract was signed before EuroGas was administratively dissolved. That's why this new case is different from our case. And then Mr. Gardner points out that in the Utah case that came out earlier this month, it happened after the partnership was dissolved. Next slide. And again, that the contract in our case was signed before the 2-year period for which the company could seek reinstatement had expired, whereas in the new case, it happened after the 2-year period. I asked Mr. Gardner whether he considered that a relevant distinction between our case and the new case, and he confirmed he thought it was relevant. Next slide. And this is again Mr. Gardner confirming that the Utah case does not deal with the same facts as our case. Now on Monday, we also heard counsel for claimants make an argument, and perhaps this is one of the arguments to which the tribunal was referring when it said it heard either new or arguments that had not been extensively discussed in the parties' submissions. As I understand the suggestion in claimant's opening statement, the notion is that even if it is just a collateral interest, it is somehow a protected investment under both the BIT and the Exit Convention, both of which would be necessary. Let me point out, members of the tribunal, that that argument, and this is the investment, it's at the heart of the case, was not in the request for arbitration. It was not in the first provisional measures briefing. It was not in the second provisional measures briefing. It was not in their memorial. There was no mention of this at all until the reply brief, and even there, it was a throwaway argument, no more than a paragraph or 2. It is not appropriate, I think, for us to be dealing with brand new allegations of what the protected investment is at this late stage. There just hasn't been a proper record for the parties to deal with something like this when so little focus has been spent on this. Virtually no notice was given of the argument. And we now are in a situation where we understand this is what they are alleging, even if in the alternative is the alleged investment. I'm going to address this, but I do so with that reservation of rights, that I don't think we have been permitted to deal with this assertion, this alleged investment, in the ordinary course. If this is a security interest, it would not constitute a qualifying investment protected by international investment law. And we, in fact, did mention this. We paid about as much attention to it as the claimants did, since they've never affirmatively made this case. And I'll show you in our brief where we did so. But the primary reason that it can't be a protected investment is because as a collateral interest held by Belmont, it does not directly arise out of a protected investment as required by Article 25.1 of the Exit Convention. Go back a slide, please. What I have up for you on the slide is Article 25, and we did assert this in our rejoinder. This is not new. The jurisdiction of the center shall extend to any legal dispute arising directly out of an investment. This dispute does not arise directly out of a collateral interest, to state the obvious. And if we go to the next slide, I'll show you, and this is one place in our rejoinder where we did assert that proposition. There are surrounding paragraphs that also discuss this in our brief. Next slide. And case law has addressed this issue in a case very familiar to my learned colleague across the table. I'm sure I'll mispronounce this, but in, it says Bernini? We had an Italian company and an Albanian company The Albanian company is Eagle Games. They brought a claim against Albania and alleged unlawful termination of Eagle Games' gaming license. Now, Barimi was not a shareholder of Eagle Games, but it asserted that it had made a protected investment into Eagle Games because it had financed a loan to one of the co-owners and it was guaranteed by a pledge of the shares. Exactly our facts. And like here, the alleged actions of the government did not interfere with the pledge. My learned colleague across the table so argued, and the tribunal so held. And in particular, they held that the dispute does not arise directly out of the pledge. And I've listed up on the screen for you here what is a quote from the case. Given the importance this issue has now taken, if you'll bear with me, I think it's important to read it. It says, however, the financing agreement by which Barimi SRO financed Ms. Alma Lika's share purchase in exchange for 90% of the profits she would receive does not represent ownership. Rather, it represents a private contractual loan agreement. Moreover, the dispute at hand does not arise out of any government measure affecting the agreement. And it goes on. Next slide. There is another independent ground from Article 25(1), and the language arises directly out of a protected investment. And it's one this tribunal is all too familiar with, and I won't spend time going into. It's the Salini test. That is the different factors that have been found by numerous tribunals to be required under Article 25(1) of the ICSID Convention, namely a transfer of economic value from Belmont to the Slovak Republic. Clearly that wasn't the case with the pledge. No effective contribution over a period of time. No contribution to the development of the Slovak Republic's economy, and of course, although not on this slide, no risk. And we also cite a third case in our papers, Joy Mining versus Egypt, that held a bank guarantee is not a contingent liability and did not fall within the definition of an investment under the ICSID Convention. Okay. Now we also noted that Mr. Garabi had made an argument on Monday that registration of the shares had not changed in the Slovak Commercial Register. This too is an argument that, although there was some mention of it in the provisional measures briefing, didn't have much focus in the parties' memorials, counter-memorials, reply, and rejoinder. The fact that registration of the shares have not changed in the Slovak Commercial Register is perfectly consistent with the position. Indeed, it supports our position and Mr. Anderson's position that Belmont retained a security interest in the transferred shares under Canadian law. Because if registration had changed, then Belmont would not have been able to hold them as collateral. So there's nothing inconsistent about the fact that the shares are registered in the Slovak Commercial Registry and Mr. Anderson's position that Belmont retained a security interest in the shares. Indeed, it's supportive of his position. More generally, we would make the remark that the claimants have offered, and it's not surprising how late in the case this issue arose, that they have offered no affirmative proof that they have registered that collateral in the Slovak Republic. And in the absence of that evidence, there is simply no proof that a collateral interest in the territory of the Slovak Republic, which is what's required under the Canada-Slovak Bilateral Investment Treaty, even exists. There's been no affirmative evidence put forward that that collateral interest was ever registered. Now, as you play this argument out that the claimants have raised, that if there is a collateral interest, that is our protected investment, think about where that leads you. If Belmont was a secured creditor, effectively, of EuroGas, then think about what happens when EuroGas goes into bankruptcy. Belmont is a secured creditor at that point. And Mr. Rollball, when ordered to provide that schedule of assets and liabilities, would have been required to disclose on that schedule that Belmont was a secured creditor of EuroGas. But importantly, in US bankruptcy law, if you don't have a perfected security interest, if you can't show that the interest was perfected, then the trustee is perfectly empowered to strip that creditor of the security interest, and it effectively comes back into the bankruptcy estate, which leads you back to exactly where we've been all along. Everything's in the bankruptcy estate. But because Mr. Rollball didn't file those schedules of assets and liabilities in direct violation of the court's order, that asset was never disclosed to the trustee. Again, members of the tribunal, as I asked you at the outset, bear in mind that it is the claimants who bear the burden of proof on showing that they have a protected investment. They have not put forward an affirmative case that their investment is merely a collateral interest. They've offered you no proof to that effect. What we have, as you know from the history of this case, is a situation where they misrepresented a fact to you, we discovered the truth, and now we are shifting positions yet again at the last minute to claim a new investment that was not suggested in the request for arbitration, in the provisional measures briefing, or in their memorial. If you were to recognize this as a protected investment, you would effectively allow the claimants to benefit from Mr. Rollball's wrongful conduct by not filing those schedules of assets and liabilities. Because if he had listed those schedules of assets and liabilities, all collateral interest disclosed would have required the trustee to investigate them. Where they are not perfected, the trustee can, as a matter of US bankruptcy law, strip the security interest from the creditor. And as we all know, under public international law, there are well-settled principles that one cannot profit from one's own wrongdoing. Those conclude my remarks about Belmont 2 and the 57% transfer. I'm now going to move to EuroGas 2. And much like the secondary Belmont jurisdictional objection, which I don't intend to cover today, but the Canadian treaty only started to apply in 2009, I will not be addressing the other EuroGas jurisdictional objection, which is the denial of benefits. And I do so again because it received very little, if any, attention this week. But I would ask that that not be construed as any suggestion that that is not a crucially important jurisdictional objection as well, if the tribunal reaches that point in its analysis where it has to deal with it. We don't think you have to, because these other jurisdictional objections require dismissal before you even reach them. The EuroGas jurisdictional objection that did receive significant attention this week is, of course, whether EuroGas 2 even owns the claim anymore. As I noted to you on Monday, we have an ever-changing jurisdictional story that started with 3 or 4 different merger theories and now appears to be that the transfer instead happened through an entity called McCollin. And you can avoid all of that. You can avoid all of that simply by concluding that EuroGas 1 did not emerge from the bankruptcy with the ICSID claim, with the asset. Because if you conclude that, then the bankruptcy estate still owns the asset, and EuroGas 2 is prosecuting a claim it doesn't own it. You don't have to deal with merger theories, you don't have to deal with McCollin theories. It's as simple as that. That's also the case if the trustee's deal that it has struck with EuroGas 2 is approved by the court, but the tribunal recognizes that it can't retroactively grant jurisdiction to this tribunal. On Monday, I gave you the example of Mr. Pekash and I, a hypothetical having a hypothetical investment, which clearly showed that couldn't be the case. In either one of those situations, if you conclude the asset was not abandoned, or even if the trustee's deal is approved, but the tribunal concludes it can't operate retroactively, you can stop there. No further analysis is needed. What about that threshold issue then, of whether the asset is still an asset of the bankruptcy? And as I said on Monday, members of the tribunal, that is an issue you will have to deal with because the trustee, under her current proposal, will not resolve the question, and I'll come to that in a moment. Before I do so, I noted Ms. Burton making an argument in the opening statement on Monday that candidly I had not heard before, another new argument. But before I get to that new argument, I actually want to turn first to that proposed deal with the trustee. Ms. Burton indicated to you that the trustee had concluded that the asset may well have been abandoned, that the trustee was making that representation in the deal that the trustee has struck with EuroGas, that the asset may well have been abandoned. As I indicated to you, the trustee is not taking a position on the issue. Indeed, it's equally correct for me to say the opposite. The trustee concluded that the asset may well not have been abandoned. The reality is she simply doesn't say. In fact, on the screen, you have a red line that was filed in the Utah Bankruptcy Court last Thursday of the proposal that Ms. Burton and EuroGas 2 made to the trustee. This is before they finalized their deal, and it's a red line. And the language that's crossed out is what the trustee rejected. And you can see that the trustee was not willing to say that there are, quote, and I'm down now at little I, the highlighted part, not willing to say that there are reasons to believe that top claims were abandoned in light of all the facts and information available to the former trustee. She specifically rejected that request. And look what she added up at the top. The trustee has concluded that A, the issue of whether the talc claims were abandoned by former trustee has not been resolved. So I hope this puts to rest any further suggestion that the trustee was or is somehow suggesting that the asset is likely abandoned or was abandoned. Trustee simply didn't decide the issue. Now you might ask yourselves why. Why, if it's as obvious as both parties are saying, does the trustee not resolve the issue? Quite obviously, she is concerned about maximizing the money for the creditors. Candidly, the trustee told us that very directly. That was the objective for the trustee, to get as much money to pay the creditors of the bankruptcy estate. EuroGas 2 is willing to pay the trustee more than we are. It's as simple as that. Now, why? Why aren't we willing to pay more? Because we think our other jurisdictional arguments, which we'll come to, merger, McCollin, denial of benefits, those are so strong that we do not need to purchase this asset against us, this ICSID claim against us, to prevail in this arbitration. So EuroGas has offered more money. And it truly is as simple as that. And the trustee knows that if she did state that the asset was not abandoned, EuroGas 2 wouldn't sign the deal and wouldn't pay the money. So although she declined EuroGas 2's specific language, asking for a declaration that the asset was abandoned, she instead decided to stay completely neutral on the question. Now, was the asset abandoned? Again, because she is not willing to resolve that question, the trustee is not. It'll be a question that falls to you, members of the tribunal. And on the issue of whether the asset was abandoned, you saw Ms. Annette Jarvis yesterday. You saw Ms. Jarvis's demeanor. You were able to judge her credibility. Her opinion was unequivocal. It was backed up by the plain language of the statute and by every court case that has ever looked at the issue. The asset could not have been abandoned by operation of law because it wasn't scheduled. And as I showed you on the slide on Monday, the statute on abandonment of property by operation of law specifically uses the word scheduled. Only scheduled property can be abandoned. Mr. Robal confirmed before you this week, he did not file schedules of assets and liabilities, and it is undisputed in the case, no one else did either. Now, even if, to stress the point that I made before, the trustee's deal were to be approved, and there would be abandonment non pro tunc, again, it still would not solve the jurisdictional problem because that cannot retroactively create jurisdiction under the BIT or under the ICSID Convention. Now, to the new theory to which I referred earlier from Ms. Burton, and candidly, it again was not a theory I had heard before, but it appears to be the theory now that the investment was not part of the bankruptcy estate at all because EuroGas 1 held it indirectly. There were called questions about how the assets that a subsidiary may own would not be listed on the schedules of assets and liabilities of a debtor. And the point that Ms. Burton made was that the bankruptcy is only concerned with the debtor's direct ownership of assets. There are two reasons why that cannot be right. The first reason is the 57%, which transferred to EuroGas 1 in 2001 and therefore would have been part of the bankruptcy, was held directly by EuroGas 1. It was not held indirectly. The 57% was EuroGas holding those shares in Rosman. No intermediate company. It was the 33% interest that EuroGas held indirectly through EuroGas GmbH. So that argument completely ignores the majority of the claim, which is the 57%. Now second, with regard to the 33%, the argument doesn't work either. And this is not the right slide to show it.
If you go to slide 37.
Ms. Jarvis was asked about this on cross-examination and explained, and I quote, again, now I'm on slide 37, quote, so for instance, the way you determine the property of the estate is you look at the property under the law that applies to determine if the debtor has a property interest. If that property interest exists, then it needs to be, then you look at whether that fits within the definition of property of the estate. So in other words, Ms. Jarvis is looking at the applicable law. Here it would be international law that would govern the property interest. And she says exactly that on the next slide, slide 38. She states, applying that principle to the facts of this case, quote, the way it works in this case is that, so when you look at the property of the estate, a right under the investment treaty would be determined under international law. Of course, makes sense, how could it be otherwise? And she continues, quote, so however the investment is defined under international law, that would be the right that the debtor has. And then you look at it. Is that property that fits within the very broad definition of property of the estate? And is it property of the estate? In this case, the investment that was made, the investment right under this treaty would have been property of EuroGas 1 under international law, and therefore would have been property of the estate under section 541. When the bankruptcy was filed, it's true the talc mines had not yet been reassigned. But EuroGas 1 had rights under the treaty when it entered into bankruptcy. And indeed, it was the only entity in the corporate chain that could own those rights. A subsidiary couldn't hold it because the subsidiaries weren't of U.S. nationality. You have to be a U.S. national to have rights under the U.S. Slovak BIT as against Slovakia. So we know going into the bankruptcy, EuroGas 1 has the treaty rights. If those rights were violated after the bankruptcy was commenced, then the claim would be derivative of those rights and therefore property of the estate. And if we look at the question the chairman asked Ms. Jarvis yesterday, he posited this situation with a perfect analogy. Suppose the debtor has a house. It exists at the time the bankruptcy starts, then there's a fire, and it's caused by the fault of someone, so it could give rise to damages. That right to damages, when you think it's property of the estate or not, Ms. Jarvis was unequivocal. Yes, it would be. Next slide. I also, well, and she continues in her testimony, quote, so even though the event happened after the bankruptcy was filed, it was related to property of the estate. It is the property of the estate. Okay, let's go back to slide 20. I want to be clear about one thing, though. Although the talc interests, more specifically the excavation area, was reassigned after the bankruptcy was reopened, those rights were reassigned before Mr. Robal was ordered to make schedules of assets and liabilities. In other words, had Mr. Robal complied with the order made directly against him by the U.S. federal judge to file those schedules of assets and liabilities, at that point, the excavation area had been reassigned. In other words, the facts giving rise to this arbitration had occurred. the ICSID claim itself would have had to be filed as a schedule of assets and liabilities. It wasn't done so because he never filed those schedules of assets and liabilities. Now, even Mr. Robal admitted that the claimants know EuroGas 2 is now prosecuting what is really EuroGas 1's claim. EuroGas 2 is really prosecuting the 1985 company's claim, and they know it, because under cross-examination, Mr. Alexander asked him questions relating to this topic, and he stated at the time, and this is a question in regard to the filing of the request for arbitration in this case, when the claimants represented themselves as EuroGas 1. At the time, I was of the opinion it's the 1985 company which is making the claim. The claimants themselves are saying they didn't believe it was EuroGas 2's claim. It was the 1985 company's claim. And Mr. Alexander, so there was no doubt, said that was your intention, to make it on behalf of the 1985 company? Answer, yes. Okay. Now I'm going to move away from that threshold issue of whether the bankruptcy, whether the ICSID claim or any other interest relating to the TALC claims was abandoned or not. Again, if you resolve that question such that you conclude that the interest was not abandoned and that the estate still owns it, even if the trustee's deal is approved, you can stop there because the tribunal will not have jurisdiction. But let's assume you disagree with the analysis I just went through, and you conclude it was somehow abandoned, or you conclude that the trustee's proposed deal, if approved, does somehow grant retroactive jurisdiction under ICSID and the BIT. We're in that world now. As I noted on Monday, there are still numerous other jurisdictional problems, because now, under this hypothetical, EuroGas 1 emerges with the asset, this ICSID claim, and it somehow has to get the asset to EuroGas 2. How does it do that? And as I told you on Monday, we've been offered now 4 or 5 different theories to do so. The way I'm going to do this is very similar to how I did it on redirect with Mr. Gardner yesterday, which is just to quickly march through them. First, we were told that it merged pursuant to what they called this Type F or Class F reorganization. I asked Mr. Gardner, my question is whether a Type F restructuring, as the claimants use that phrase, can merge 2 corporate entities. He was definitive, no, it cannot. Next slide. What about the second theory, this joint unanimous consent resolution? I asked him, can that affect a merger? No, he said. I asked him why, and you can read his explanation below, but picking up at the highlighted part at the end, he said, one company can't, just by resolution, and by the way, the directors are the same on both sides, decide that the shareholders of one company are now the shareholders of another company. That just doesn't work, at least not in Utah corporate law. And if we go to the next slide, I had asked him, what is the way that companies can merge under Utah law? How does this happen then, lawfully? And he said there is but one way, statutory merger. And statutory merger, he explained, requires filing of articles of merger with the Office of State Corporations. And I asked him when that merger becomes effective, because in addition to transferring the asset from one entity to the other, EuroGas must also make it retroactive to try to cover all of the events that occurred here. And he said it only becomes effective when the articles of merger are filed. And you can see that up on this slide here. If you go to the next slide. This is where I asked him, is there any other way to merge in Utah lawfully? Mr. Gardner, I am not aware of any other way. Next slide. In fact, and now I'm focused on the retroactive nature of the merger they purport to engage in. Ms. Jarvis identified 2 independent reasons that that retroactive merger cannot work. she states, picking up on line 3, I think Sam Gardner had stated that under Utah law, it cannot merge retroactively. That's the first reason. It's only effective when articles of merger are filed, and they never were here. And then she states, and if you're asking for something to come in effect at the time the automatic stay is in place, that would be void. In other words, the retroactive nature of the merger would have gone back to 2005 when EuroGas 1 was in bankruptcy, and there's an automatic stay in place that prohibits anyone from doing anything with the assets of the debtor. So if there was a purported merger, and even if the merger did take place, it couldn't apply retroactively because there was a mandatory stay in the bankruptcy. And as she notes, any action taken in violation of the stay is void ab initio, absolutely void. Next slide. In response to a question from members of the tribunal, Mr. Gardner was asked about whether merger can be consistent with wind-up activities. As a dissolved corporation under Utah law, the only activity that EuroGas 1 was permitted to engage in was wind-up activities. And he said, it's pretty clear. There's not a whole lot of gray area here, to paraphrase. He says, quote, for example, in my view, a merger is something different from winding up a corporation because a merger actually is a means by which the business of a company is continued. And it continues on rather than ceasing operations and ceasing the process. A merger, that's what that does. So a sale of assets is different from that. In other words, a merger is the exact opposite of a winding up activity. It's continuing the business rather than ceasing it. Next slide. And now we come to the application of the new authority that Mr. Gardner found yesterday to EuroGas's jurisdictional objection. I touched on this briefly about why it doesn't apply to the Belmont transaction, because there the contract was entered into before EuroGas 1 was dissolved, and it occurred prior to the expiration of the 2-year reinstatement period. It does apply here to the EuroGas purported transfer of the ICSID claim to EuroGas 2. Why? Because just like in that new case, that purported transaction occurred after EuroGas 1 was dissolved and after the 2-year reinstatement period. And while Mr. Gardner expressed his view that he thought the court should have come out differently, he acknowledged, in my view, it is binding law. And this is why Mr. Gardner, when I asked him, does this new case support your conclusions, your ultimate conclusions, or weaken them? He said, it supports my conclusions. If you see the excerpt on slide 49, I said, overall, he said, overall, by the way it reads, it strengthens, that's his words, his position. I say, why do you say that? He said, because my portion of the report focuses on merger and whether a merger occurred or not. And if we assume for the sake of argument that a contract was entered into for a merger, this case supports the conclusion that the contract would be void, not just voidable. And I said to him, and you have other reasons in your report to conclude that? And he says, yes. He says, my answer is, it provides additional reasons for my conclusions, paraphrasing, that I wasn't aware of when we wrote the report. Next slide. Okay. I want to make one other remark. We have seen, I showed you on Monday, it was clear again throughout the course of this week, the Type F restructuring argument has been abandoned, explicitly so. The joint consent resolution, as we've seen, Utah law expert has stated it has no effect. In fact, Mr. Gardner, you'll recall, stated it was not a transfer document. It was not a document that could actually transfer an asset. You've seen that. What about de facto merger? Remember the de facto common law merger doctrine we saw? And on Monday I spent a lot of time talking about how they're all successor liability cases rather than actually cases that merge two companies. That appears now to have been abandoned as well. We heard nothing about it in Claimant's opening statement. When the two Utah law experts were being cross-examined yesterday, they weren't asked a single question about it, which meant I couldn't ask a single question about it on my Indirect. It appears as though that argument too has now fallen by the wayside. So we are literally on theory number 5. And theory number 5 appears to still be that the asset somehow made its way to EuroGas 2 indirectly because of a transaction that was made with McCollin. You'll recall I discussed this on Monday. Just by way of a very brief refresher, the allegation, made only in the reply for the first time, is that EuroGas 1 transferred the shares in GmbH to a UK entity called McCollin in 2007. We know the date of that transaction. And then at some unspecified time in the future, EuroGas 2 acquires the McCollin shares, and therefore indirectly the EuroGas shares, and then indirectly the Rosman shares. And that's now the investment. And I said repeatedly on Monday that even though claimants introduced 5 new documents into the record just last week purporting to show when all this occurred and that it had occurred, if you look at those documents carefully, they don't tell you. They're option agreements. They are documents that purport to show what occurred later with EuroGas AG, a Swiss entity in 2012. They do not tell you when EuroGas 2 acquired the shares in McCollin and therefore EuroGas GmbH. And that's the investment. So I was expecting during the opening statement to hear the date on which the investment was made, which is crucially important because you have to compare that date against when the alleged bad acts in this case were occurring to determine what you have jurisdiction to even consider. And instead, what we were told, and this was no mistake because it was said twice, this is counsel for EuroGas stating, as of November 2011, EuroGas owned all of the investment. And the next slide, no later than November 2012. Members of the tribunal, a sovereign nation is being sued for hundreds of millions of dollars, and we have not even been told when the investment was made, and we have no evidence that it was even made. So as we sit here today, 2 years after this case started, now after a week of proceedings, after entering 5 new, brand new documents into the record last week, we still don't know when the investment was made. On any objective view, that is a failure to carry your burden of proof to establish the facts necessary for the tribunal's jurisdiction. Unless there's any questions from the tribunal, I'll close my remarks on jurisdiction with that point. Again, we rely on our papers and the comments we made on Monday with respect to the jurisdictional objection that EuroGas 2 was properly denied the benefits of the treaty, and specifically the arbitration right, and that right was denied prospectively, not retroactively, as well as retroactive denial of the actual substantive provisions of the treaty. Thank you, Mr. Chairman.
Thank you. Well, I think the tribunal may have questions, but that would come afterwards, after the end of your oral arguments. When do we make the break?
I leave it up to you.
We can start now, and maybe break in the middle.
As you wish. Whenever you want me to break or find a moment.
By the way, let's have a 5-minute break.
I don't blame it on you.
Thank you, Mr. Chairman. On this preliminary matter, we have a second member of the Française who would like to attend and to assign the undertaking. I believe respondent doesn't have any objections, and we just wanted to ask if you did.
I didn't hear the beginning of your sentence.
We have a second member from La Française, the founder, who would like to attend the hearing this afternoon. She has signed an undertaking. Her name is Pauline Atwood. We believe we have respondent's consent, and that's why
The second member of
La Française.
The third-party funder
That's
is
the
the second
third
representative here, and I confirm that respondent has no objection.
we don't have an objection.
Thank you.
Good. For purposes of the closing statement, I would be referring to a binder, which we'll call the third binder of claimants amongst the hearing bundles of claimants. And I would be relying on this third bundle plus the 2 bundles for the opening statements that I used. And the numbering of the third binder follows the binder 2.
And we'll start with
Good question. Just to have
here.
the combination of the, would you prefer that I start with the merits or jurisdiction? Okay. Okay, I will start with jurisdiction. Then if you could keep the first two ones. I will start, President Meyer, Professor Gaillard, Professor Stern. Belmont will start with its closing statement. It will address jurisdictions that are specific to Belmont before addressing the merits. Then it will give the floor, if you don't mind, to EuroGas for it to address its specific jurisdiction objections. Before I start with the jurisdiction, I would like to make a few, maybe 3 preliminary comments. The first comment are the allegations of impropriety, procedural impropriety, and other impropriety made by respondent during its opening statement, and again at closing. And here we go, we hear again the solid state victims of wrongdoers. Suggestion is made that there are lies that are conveyed on this side of the table, and documents, information hidden. As far as Belmont is concerned, we wanted to reiterate that we are a good standing publicly listed company in Canada and in Germany. We make public statements, and I believe the respondent is heavily relying on public statements, that we've made financial statements. So by essence, it's odd to rely on documents to allege dissimulation, allege documents that are public. We have at the outset of the proceedings been given the order for production of documents, and we have given all the documents that we have, and mainly those other documents are in favor of our position. And plus they have taken all of the documents of Rosman by way of the criminal proceedings, so they have all of our documents from the outset. So any suggestions of dissimulation of the evidence was quite, I would say, laughable in the circumstances. Now, as to the witnesses, suggestion has been made that they could lie, should be sequestrated. We offered Mr. Egagos, he came, he was direct in his answers, he answered all the questions, he didn't go around to buy time or answer other questions. Mr. Robo, we offered that he come immediately after. When a break was accepted, we said at least put him under oath, we proposed. And when he took the stand, he responded to all questions. I thought it would go, according for listening to Claimant, respondent, I thought they would implode or explode on cross-examination. Nothing came out of their mouth that was inconsistent or suggested dissimulation. Only Mr. Robo accepted that he was a wishful thinker in portraying that he could pay the purchase price until the end and obtain the transfer of the shares. Otherwise, strictly nothing came out in favor of the respondent. And the only useful information which we entertaining is that the two shared their ex-wives in common. Apart from that, no. Now, regarding respondent, if I could make a general preliminary remark, is that their factual witnesses is wow. Useful, entertaining. We thank respondent and think that, imagine these are the two that they fought in support their case. I have no choice but to put Mr. Igaios. I cannot pick and choose of Mr. Rosgoznik or EuroGas with Belmont. They had a choice and they decided to bring Mr. Chorich and the other gentleman from the MMO. Imagine what are the others. I mean, Mr. Chorich is a, it reminds me, I don't know, we have a generation gap with others, but the personage, the Starsky Hutch, the one and only character, never answers a question. One, he speaks with his heart. You say, I wanted to kick out the others prior to the revocation because I like, it's my heart to talk, I like it. Then, what about extraction? Oh, I'm a director, I'm a technician, I'm a sportsman. Did you meet with him? Oh, I met with him at the restaurant in his personal capacity, his professional capacity, twice, 3 times. Did you write? No, I didn't write to the government. Oh, this is a document. Oh, why are you bad-mouthing? We didn't bad-mouth. Look, I sold the shares, he says, back then for a nominal value. Here's the receipt. How could you sell for nominal value? Here's the receipt plus. Oh, I didn't receive the money. I didn't receive it in cash first. He said, then pushed it. Oh, I didn't receive it. But my signature, oh, it may be my signature. Did you try to find out? No, I didn't. I had this document sitting around, the pleadings. Anyways, you were served lies, members of the tribunal, lies, and only lies. And the other gentleman, Mr. Ukilchik, was candid, but pathological and damning to its case. Because what did he say, basically? He said, Roseman, they didn't need to be warned, they didn't need to be explained what the law was, it's their job, we're not there for them, tough luck. That's what he says. And due process to review, to look at others, regularity, due process, everything was regular, move on. There is this law, we applied the law, and there could be nothing wrong. What about the documents that we were supposed to disclose that we threw in that shows that Mr. Cheller from the district or main mining office was in contact with Mondo prior to the, oh, it's not good, it's prohibited, it's irregular. But did you try to find out? No. How come? They're in the records, we submitted it. Oh, because nobody brought it to my attention, but he read the reply, he submitted a second reply, rebuttal, addressing peripheral question of stamping and administrative, it's some act of his email of his administration that would qualify as irregular, that is on the record. He didn't see it, he didn't hear about it, of course he doesn't want to talk about it. As to the other email that you excluded, but it was referred to us, of course, no mention was made of it to him. He didn't inquire, so it does not exist, we don't talk about it, I don't want to hear about it. Again, pure lies on material issues in relation to the merits. Now, the last preliminary remark, and this is not to object, contrary, or reserve our rights. We have no reservation of rights. As far as Belmont is concerned, we are blessed with a nice tribunal. We are grateful to this tribunal, the way they have conducted these proceedings. We apologize, we could not hold the previous hearing, but it was due to respondent, and as you can see, there is a real conflict of interest as far as jurisdiction is concerned that required 2 different counsels for representation of the 2 different claimants. But we are upset, Mr. President. We are upset. We are grateful with no reservations of that, but we are upset. Why are we upset? For 2 reasons. The first reason is the provisional measures. And I do not want to reopen that, but I think there are consequences to that that you still can rectify. sovereign state can do what it wishes in terms of criminal proceedings conducting its affairs, but not to touch upon the integrity of the process. Here, in terms of timing, once we got out of the hamster wheel, they entertained for months and months the prospects of a payment of a compensation to us. They knew the date we were filing, and they used this time to trigger criminal proceedings to take all the documents of the file. So in terms of timing, it was directly related to these proceedings. In terms of substance, they founded it, they based it on the fact that we're initiating an arbitration for a high amount, and they could only be a fraud. And again, there was no allegation to the EuroGas story. They came and got all of our documents, including privileged documents. We wrote to the EU Commission, because when there is a sovereign EU state that is defending, it has to inform EU the way it is defending, and we constituted the tribunal. So they had to restitute and stop their nonsense, but the damage was done. Basically, your order said, it's done, well, the council undertook not to read it, remove it, but that's not fair. It's not fair for two reasons itself, because it created an unbalance. They have all of our documents, including privileged documents. We don't have their documents. Two, it's a green light for tomorrow for all states to say, okay, poof, let's start. They're starting an arbitration. Let's rate them. Let's get them. We'll get a tribunal, and we'll restitute them. That's the practical implication of the order. The second thing we were upset about that is related is our document production order. We have to beg for documents. You order them, they don't provide them. We show that they are lying. We undergo the burden of finding them. We disclose them. Others, as a practitioner, we know very well that we need the consent because it's sensitive, some of them, especially if there is tender communication with an administration during the tender process with the body giving insider information to the tender participant. We got it at the eve because people, some want money for it, they see that they cannot get it, or they are afraid and they say, okay, it's the last opportunity to help, and they finally give it upon pressure. And what excuse did we receive for not producing them? Oh, one line in a document without any explanation. They provided substantiation for the affidavit. For this was one line, and then they said, it's classified. It's classified, we close, it's finished. How it's classified? Who did you ask? When did you ask? What search was carried out? And at the hearing, we found out that nobody had even brought it to the attention of Mr. Kukevci. He had not done, he didn't know. And he didn't make any inquiries. And I would add, what classification of documents? He didn't say after a certain years, my documents are classified. How can an email be classified? He said they are printed, they're there. He didn't say even the computer, they're destroyed. And so for all these reasons, we think that it is completely inappropriate, but that at the very least, the tribunal should draw serious inferences specific to this case, and so as not to allow other sovereign states, including the Slovak Republic, to get away with it and start violating the integrity of the process and the tribunal's orders in this way. Now I get to jurisdiction as far as Belmont is concerned. Your direction, Mr. President, was very blunt. You said address on both sides the other sides' opening statements, including some of the new arguments that the other side may have put forward. We will certainly obey your instructions as far as the merits are concerned. We will address Slovak law, because I think that was your specific request. I am disappointed by respondent's presentation because it didn't address our jurisdictional, our defenses to the jurisdictional objections. And I'm also upset because I spend a lot of time reading Occidental, going back, reading Benderman's article on the Iran-US claims tribunal, looking at all the BITs, nothing. The primary jurisdictional defense to the objection we had are the clear and unambiguous on ambiguous terms of the BIT. I did not hear a single response to our presentation. And our position was clear from the outset. Title, mere title, which undisputedly we have to the shares, entitle us to jurisdiction. And I went through great detail in walking you through the text of the treaty to say even more so in this case, given the terms of the treaty that use hold or invested directly, indirectly, and with investors not being defined. I walked you to the treaties of claimant, of respondent, both signed, where when they wanted to have the ownership plus control or have the investor carry out certain investment, they did so expressly. In this case, they did not. And what respondent has come up with is accidental. It's the only case it has. I distinguished it by saying the terms of that treaty were completely different, doesn't use the words hold. And then it relies on a fact-specific case that I went through the trouble of reading that has strictly nothing to do with our case, where beneficial ownership was clearly transferred from the outset. And nothing, zero rebuttal. Now, I anticipate perhaps the defenses you would raise or that may indirectly be transposed in some way to this defense that is our primary defense to jurisdictional objections. Mainly, for example, that the exit convention contains specific standalone jurisdictional grounds of its own. Well, the Malaysian annulment case, presided by Judge Schwebel, said no, the BIT contains standalone jurisdictional clauses that allow an investor to exercise exit jurisdiction. I'll go a little bit step further with you and do the job the respondent could have started to do, although I don't think it is persuasive, but I do that by the abundance of caution. Assume you would look at the exit convention and the BIT, and not BIT as a standalone, because if you look at it, especially with the zero defense we got to our primary case that was put straightforward, you can only conclude in favor of jurisdiction based on claimant's, respondent's factual primary case, that we only hold the shares, not even necessary to look at collateral. Why? Because in this case, you have evidence that is undisputed on the record that we exercised some control. We were the initial, on respondent's case, best case scenario, at the beginning, there is no dispute that we were beneficial and legal owners. Then when respondent claims, and we know, we will get to how it claims, that we somehow transferred, notwithstanding the clear terms of the SPA title, beneficial title, we still, the records show, exercised control. We kept the title, and also invested in 2001, 2002, 2003, 2004. So heads or tails, we have jurisdictional objections, and they stand unrebutted. Now, for the sake of completion, I will address the second alternative defense, is that assuming the BIT and the facts were not as such, did we transfer beneficial ownership? And the answer is clearly no. Why? We have not transferred beneficial ownership. If you go to the SPA, it should be tab 57 R0107, simply because of the clear terms of the contract. What are the clear terms of the contract? We want to prove them again yesterday. It has an Article 6. It is entitled closing. It contains conditions. It provides the transfer of shares to a trust. The shares were never transferred to a trust. And it clearly says the ownership of the shares shall not pass to the purchaser. These are two professionals. The ownership of the shares shall not pass to the purchasers. They don't say half of the ownership of the shares or 1/3 of it, or the P of the ownership passes, the W remains. It says the ownership shall not pass to the purchaser, and instructions to proceed with the share transfer not be given unless and until the vendor has received 100%, 125%, up to $3 million. Now, it is undisputed that their conditions have not been met. We have never met the 3 million, forget about 100. It's undisputed that the conditions have not been met. It's undisputable that it has not been placed in trust. Nobody has ever claimed closure. Never someone has asked for transfer of the shares. So what do we have? What do we have? Based on this, it is enough to dismiss the objections of respondent. But let's go and look at what they have. They rely on something that we may have dissimulated, they claim, but this cannot be possible because they rely on the financial statements that are public. The financial statements cannot be read alone as if, like Mr. Kurkovich, the others didn't exist. I don't see that, I look at that, I look at the part of the paragraph, I don't look at that. First, this financial statement is what it is, it's a financial statement. It has to be read in conjunction with the SPA, the terms of which are clear for a public company. And it says, we keep the shares guaranteed until realization, until realization. Everywhere, in every document, there is clear reference to the SPA, which the terms of which are clear, and clearly says that outstanding amounts are to be received. Now, what else can we add? Apart to the fact that it is clearly a conditional sale. In French, we say réserve de propriété. I don't know how one can go around it. I will engage with Mr. Anderson again to wrap up what we discussed yesterday. First, with all due respect, Mr. Anderson is extremely charming, he's lovely, he must be one of the most best corporate lawyers, band 4 or band 1, does not matter. But if he's an expert on contractual litigation, interpretation of the contract, or reading what the contract is, then I'm a sexy blonde from Sweden. The guy never went before a judge. He never wrote an article on the subject. I mean, it's extraordinary. It is extraordinary. And respondent said, oh, they provided a band for corporate lawyer that never litigated, never wrote an article on this, and said, oh, it was not rebutted because they could not find anybody in Canada that would say the contrary. I mean, that thing is so laughable that it is not even worth to spend some time, but it is entertaining. That's why I want to go through it. With the gentleman, we're in agreement that the clear terms of the contract must prevail. This we're in agreement. So instead of stopping there and saying, okay, it's a conditional sale, he says, no. It would lead to absurd results. And for absurd, he cites cases that have nothing to do with the absurd criteria to enable you to depart from the terms of the contract. But let that be. Why does he say it's absurd? He says, because then, Belmont can abuse of that, or the triggering amount may not be reached, then what do? Well, I tell him, you look at the terms of the contract. Look, turn the page, Article 4, you issued the new shares. That's been expressly contemplated. How straightforward could that be? He said, but you need to rewrite it. That's how you need to rewrite it. You just turn the page, it's written. It's written. Then he said, oh, then he goes and abandons that a little bit. He said, it's sloppy. I said, what do you mean it's sloppy? For us, it's good. We retain some money and we retain the shares. Well, but for the purchaser, the case law you cited says precisely there are principles of common law, so you don't need to undo the clear terms of the contract, unjust enrichment. And then it goes on to say even unjust enrichment is not appropriate to restore the balance between the negotiation power between the parties. But he nevertheless goes on, that I'll go engage with you again, he goes on to say, no, let's move out of this. How? I see principles of interpretation. Then here, extraordinary, burden of proof, oh, I didn't address that. Standing, well, if both parties to the contract agree on the terms of interpretation, or if you take away EuroGas, it's EuroGas too, the signatories of the agreements are there. They confirm that they have the same understanding. They are both professionals. Did you look at whether or not they were professionals? He didn't take care. Look at that. Said, no, burden of proof standard. It's not my thing, really. Well, okay. Professional, now I didn't ask. Well, then what did you do then? How do you arrive with this conclusion? And then he moves on to say, oof, what are you? What am I then? He said, you hold a collateral. I said, a collateral? A security under Canadian law? I mean, I spoke to people, I read. It's a complex mechanism to create a security. How do you suggest under which provision of law? He said, I don't know, I'm not an expert. You don't know either, he told me. He said, I'm fine the way I am. I have the legal title. It's your theory. You have to prove to me these steps to get here, and then how do I become security holder under Canadians? Well, I spoke to my partner who told me that they could be some basis to claim security right. I mean, that they're serving on you. Then I say, okay, then what does it become? Nobody's claiming it was brought before the bankruptcy. It leaves it off as that. And then what about the other correspondence? They said, no, you don't look at them. You don't look at them, you look at their, when I say when you look at their, you see it's clear, it's, but there are financial statements. So well, if you want to go further, then look at everything. Did you look at the Belmont's declaration? No, some of them I didn't look in the second report. It's not serious. The term is a conditional sale. Nobody has claimed otherwise. I asked repeatedly, both of the Mr. Robal and Mr. Aguiagos, Mr. Robal is hearing day 2 at page 95. When you issued those, did anyone at the Stock Venture Exchange, EuroGas 1, EuroGas 2, Mr. Robal, that's Mr. Aguiagos, I'm sorry, anyone in the world challenge the fact that this was inconsistent with your financial statement? I'm talking about the press release in the later in 2000 when he claimed full exercise of this right. He said no. I said, are you aware of anyone except the Slovak Republic? No. I asked the same question to Mr. Robal. No. Then what do they have? They have bits and pieces of the criminal proceedings. I asked Mr. Robal, what was that declaration he made? He said wishful thinking. Wishful thinking, yes. He always thinks he's going to complete something. Then I said, what about the $100 million you suggest in your wording you paid? He said, no, I should not have put it that way. And the quotes from Mr. Aguiagos, if you take one document, I would like you to read your transcript if you go within a corruption proceeding before a prosecutor, whether you would engage in detail. So I sold it sometime referring to the SPA. I don't have direct access. Right? How do you measure that with the unbalance of the clear terms of the contract the truckload of correspondence that shows that there was, that all this was subject to completion, truckload of correspondence showing that there was no transfer, and all the acrobatic steps offered by my dear colleague, Mr. Anderson, to arrive where he wants to get. Now, I will go a step further, address a very provision in Utah law to say, in any event, the sale purchase agreement, when we entered it, we had no clue that it was a dissolved company. The venture exchange, final approval, no mention, no disclosure, no information was provided that the dissolved company would be entering this. And had my client known that EuroGas 1 was in this situation, it would never have contracted with somebody at that position. And that is clear. But if we pass that stage, we go to whether EuroGas could have closed the deal. And I believe the best case scenario provided by Mr. Gardner on this issue is that winding up is possible after dissolution. There is a common agreement between the parties that the company was dissolved at the time of closure, but the contract was entered before that. And suggestion has been put to he's been fed basically on redirect with the suggestion that the contract was entered into before and that he should propose something else. And he did the best he could by relying on the Utah Code provision that you find at paragraph at tab 73, which is R19. He says, well, he can dispose. He says it is a winding up activity. Well, there is no distinction under that clause 1610A 1405 effect of dissolution, whether or not you entered before the contract or afterwards, really. It says a dissolved corporation continues its corporate existence but may not carry on any business. May not carry on any business. Then it says except appropriate to wind up and liquidate its business and affairs, and it gives a non-exhaustive list of activities. Now we're talking about Mr. Anderson's theory, let's say, of absurd result. How compatible is it to make the suggestion that to try to come up with money, because at that time and still today the money had not been paid, that finding money to pay, to close a transaction that would give you a 57% majority shareholding of a company in Slovakia could constitute winding up. I think the whole argument, the suggestion defies common sense. Now, if you want to pass that suggestion, let's look at the text. It says collecting its assets. Is that a collection of assets? The transaction has not closed. I could understand if the full payment price has been paid and you want and can get your asset. But if, as of today, $1.5 million, that agreement was valid, which is not, remain, and the company is dissolving, how could that be collection of assets? Could it be disposing of its properties? No, disposing it, selling. Discharging or making provision for discharging its liabilities? Who is asking them to discharge their liabilities? Who can benefit? Who can claim that? Distributing its remaining property? No. Doing every other act necessary to wind up and liquidate? No. I mean, on the plain reading of that law, and I don't even need to go to the new case that says that is the kiss of death if applied as far as the jurisdictional objections concerned regarding Belmont. On its face, the fact that the company went into dissolution puts a fatal blow to respondent's jurisdictional objection. And finally, assume the reading of Mr. Gardner is correct. Where does he take it? Nobody claimed performance on either side, who first can claim performance? It's us. We should be the aggrieved party. Is it them? Nobody's claiming. The whole asset was even, that transaction was openly, you have, discussed during the bankruptcy court. And the gentleman didn't lie. He said that money wasn't outstanding. It was outstanding at the time. Nobody claims it was paid. Nobody claims that that money could be found even to pay. Now, that leaves me with the fourth alternative defense to the jurisdictional objections, is that assuming Mr. Anderson, everything I said about the treaty language, about the interpretation, if we go there, of the contract, the solution of the company, if you put that in the trash, remains Mr. Anderson's suggestion that we hold some sort of guarantee only, although nobody's claiming it. Nobody's claiming beneficial ownership. There is no even split suggested anywhere between legal and beneficial ownership. Well, we exercise it. It's rolled to the world. We give the notice. It's been disclosed to everybody. And we de facto exercise. We own it. There's no provision allowing us even to restitute the money. And you put the question, or I put the question to Mr. Robel, and said, well, we considered perhaps restitution of the amount, but that would entertain maybe a counterclaim. Yes, we'll have a counterclaim because we had issues with the successive delays that caused damages to my client. And fifth alternative claim, security, assume that we only have security, we can only have security, we're bound for life, although nobody in the world except Slovak Republic is claiming this. We only have security, we cannot obtain it, and we cannot exercise close on the security. With the term loose being security, and all this, they say the burden of proof is on us. It's just funny. Okay, then still we fall under the bid. Why? Because it provides what it provides. It says hold, security, pledge, expressly identified. Moreover, we performed, as I mentioned, control by going, there is evidence unrebutted that we were in October 2004 at the district mining office with Mr. Baffy, Mr. Roslosnik, Mr. Egiagos. There is unrebutted evidence that 2002, 2003, 2004, we paid. There are amendments to the SPA saying, okay, take that into consideration even if you want to close, that we're not going to sell you even if you can perform. Nobody, by the way, talks about that. Nobody talks about that in the alternative theories, Mr. Anderson. What do you do about that? Clearly stated, for every 10,000, 1% comes back, up to 57%, with the option for us to buy the remaining 43. We paid 400. Why is nobody discussing that? Is it up to us then to also suggest 10th alternative theories in defense? Collateral. Now, the only objections we had is based on the case that we argued for the Republic of Albania for regarding against Burimi, whose case was dismissed on the ground that a mere share was a pledge, pledge agreement was not enough. But that case, again, rebuttals are great, spending time is good to engage, but one has to read the case, which we bothered to read, and that case has strictly nothing to do. Here, we're holding, at the very least, legal title. Okay? At the very least, we're holding legal title, which is being construed by respondent as a collateral. In the other Burimi case, they came to parties, to one that clearly didn't have jurisdiction otherwise, that had no direct involvement in the project. His name never appeared anywhere in the project. Suddenly popped up, like a Salafakis type, a private agreement with some notary stamp. Say, oh, Cuckoo, it's me. I have a loan, I have a pledge. It's me, the investment. I have the treaty. It's me. It has nothing to do with this. Again, we were the initial, at the very least, according to respondent, the initial full beneficial and legal holders of the claims. We held title. The collateral is something respondent is relying on, whereas in the other one was the best case scenario of claimant. Here's the best scenario of respondent. We provided money, we showed control. And finally, the most damning is, why don't somebody look at the terms of the agreement, for Christ's sake? We're here on a treaty BIT claim. It says hold, the other one says the term investment means whatever the legal form chosen by the legal and reference, every asset invested. BIT term between the countries. Every asset invested by investors of one country in the territory of the other. It doesn't say direct, indirect, let alone holding. Then it goes on to say the term investor means a legal entity of a contracting party which has made, granted, or assumed to have obtained the necessary authorization, irrevocable obligation to make an investment. So again, that is has strictly nothing to do with our case. And I'm happy to inform you that I'm done with Belmont, and I can ready to proceed on the merits whenever. If you prefer, we leave it really up to you. We're actually we help to help you.
If claimants do not mind, we could hear Ms. Burton now.
All right, you'll hear me now. First, I do want to take the opportunity to say thank you for allowing me to appear in this tribunal. I consider it an honor to have been able to be here this week and to help present my client's positions to you. When I spoke with you early on Monday with regard to the opening arguments, with regard to the attempts by the Slovak Republic to impose the terms and provisions of the bankruptcy code as an overlay onto the bilateral treaty, I cautioned the tribunal, do not try to fit a square peg into a round hole, because the statute and the treaty are completely different. They serve different purposes. They have different policies that underlie them. And I think that that has come out to a large extent in the evidence that's been produced. And you've seen some of the difficulties that you can face when you try to apply the provisions of the bankruptcy code onto the terms of the treaty. I believe that your decision in this particular matter is guided not by the bankruptcy code, but by the policies and purposes of the treaty, which are spelled out in the treaty at Exhibit C1. The treaty's goal is to foster investment between countries. And I believe that your purpose is to assist in that goal, guided by those provisions and by those purposes and policies. The bankruptcy code has a completely different goal. It doesn't foster international investment. Its goal is to help resolve commercial disputes that involve companies that are in economic distress, and to find an equitable way to treat the creditors of that enterprise. It's a completely different policy than the one that you serve when you make your decisions on these international disputes. I believe that giving due respect to the plain language of the bankruptcy code and the plain language of the bilateral treaty, as well as the plain language of the Utah Corporations Act, you can resolve whatever jurisdictional issue you believe may face you, and the standing issues that the bankruptcy case provides or presents to you. I had mentioned in my opening statement that the concept of an investment under the bilateral treaty is different from the concept of property of the estate under the bankruptcy code. And the evidence that you've been given this week bears that out. You understand that property and investment under the bilateral treaty is quite broad. And it includes property that is owned or controlled directly or indirectly by a national or company of one of the parties. And that word indirectly and the word control are critical because those provide critical differences between what is an investment under the treaty and what is property of the bankruptcy estate under the bankruptcy code. As is stated in the expert reports of the bankruptcy experts in front of you, and since I believe a lot of what they say with regard to my argument is the same, I'm going to rely on Annette Jarvis's opinion. I think the ability to rely on the opposing party's opinion and still convince the decision maker is pretty persuasive. Property of the estate includes all legal and equitable interests in property owned by the debtor as of the date the case is commenced. Ms. Jarvis agreed with that. She says it in her report and she testified to that. In this particular case, the 1985 company's bankruptcy case was commenced on May 18th, 2004. Consequently, its property, the property of that estate, is determined by looking at what are the legal and equitable interests that it owned as of that date. Ms. Jarvis agreed with me that the determination of what is property of the estate is really a two-step process because the bankruptcy code does not determine property rights. Non-bankruptcy law determines property rights. And you may remember our discussion that real estate rights are determined by state law, corporate property rights are determined by corporate law, and intellectual property rights are determined by intellectual property law. And rights under a bilateral treaty are governed by international law. And she described a two-step process. The first step being to determine under the applicable non-bankruptcy law what is the nature of the ownership interest in the asset. And then two, take that determination and ascertain if that interest existed as of the date the case was commenced. Property of the estate, I submit, and I believe that the testimony of Ms. Jarvis supports that, does not include property which is held indirectly by the debtor, whereas an investment under the bilateral treaty does include an investment that is indirectly owned or controlled by the debtor. You probably recall the discussion I had with Ms. Jarvis about parent and subsidiary corporations, and that if they file bankruptcy, they list their assets separately on forms that are promulgated specifically for that purpose. The parent corporation would list on its schedules of assets in its bankruptcy its assets, including its ownership interest, its stock, and the subsidiary. The subsidiary corporation would list on its asset schedules its assets, its equipment, its cash, its inventory, but the subsidiary's assets do not appear on the asset schedules that are filed by the parent. That's because the bankruptcy code recognizes the separation on ownership between a parent and a subsidiary, whereas the bilateral treaty recognizes the right of an indirect investment to grant standing and jurisdiction under the bilateral treaty. Further, I think this is shown by Ms. Jarvis's agreement in our discussion where we discussed the termination of Rosman's mining rights after it was placed into bankruptcy. and that the claims that termination gave Rosman the right to pursue against the Slovak Republic in the Slovak courts were not property of the 1985 company's bankruptcy estate. Nor did Rosman's prosecution of those claims violate the automatic stay in the 1985 company's bankruptcy estate. To give a little more clarification, if a United States corporation owns several subsidiaries, one subsidiary holds mining rights and permits to operate a talc mine in the Slovak Republic. A second subsidiary is an equipment leasing company which leases equipment to that first subsidiary for use in its mining operations. And a third subsidiary which develops mining technologies which it licenses to the subsidiary that's operating the talc mine. The U.S. parent under the bilateral treaty would qualify as an investor because the bilateral treaty recognizes indirect ownership as a basis for standing to prosecute a claim. However, if the U.S. corporation filed a bankruptcy petition, its property of its bankruptcy estate would not include the mining rights of the first subsidiary, the equipment of its second subsidiary, or the intellectual property of the third. This is why I told you in my opening statement that the concept of an investment under the bilateral treaty is broader than the concept of property of the estate under the bankruptcy code. Even though, as Ms. Jarvis testified, and I agree with her, the concept of property of a bankruptcy estate is very broad, and it's intended to be broad. But because the bilateral treaty goes farther and recognizes rights of an investor whose investment is merely indirect, or who controls an investment without owning it, is even broader. An additional clarification for you, I think, can come from this. If you have two United States corporations, the first one provides equipment to a company in the Slovak Republic for use in mining talc, and a second one, which is unaffiliated with the first, provides intellectual property to that same Slovak Republic talc mining company. Both of those U.S. corporations have investments that are recognized by the treaty, but they could not file a joint bankruptcy case. They would have to be debtors in separate bankruptcy cases. The next concept has to do with the termination of Rosman's mining rights after the 1985 company was placed into bankruptcy. The concept I want to discuss with you at this point is that property of the estate does not include property acquired by the debtor after the case is filed. I discussed this with Ms. Jarvis, and you'll see that discussion at the Day 4 transcript at page 35. We discussed an example in an individual person's bankruptcy case where an individual files bankruptcy on May 18th, 2004, and on June 1st, 2004 receives income from his or her employment. That income would not be property of that individual's bankruptcy estate because it is acquired after the filing. I think when you distill the discussion down that Ms. Jarvis and I had is that property that's acquired by a debtor after the filing of the bankruptcy case will be property of the estate in certain circumstances. If it's proceeds of property, for example, if the trustee sells property of the estate, the proceeds of that will be an asset. In addition, if the claim, and let's assume a claim arises, if that claim is related to property that the bankruptcy debtor owned on the date that it filed bankruptcy, that will also be property of the bankruptcy estate. Ms. Jarvis testified to a particular case for that proposition, and it's known as the Brumfield case. It's a case of an individual person, not a corporation. But in that particular instance, it was clear when Ms. Brumfield filed a bankruptcy, she owned a home. The home was subject to a mortgage. The mortgage company was foreclosing. All of that was in existence when she filed. And she knew of facts that would give rise to a counterclaim that she wanted to assert. That counterclaim, even though it didn't come into ripeness for her to be able to prosecute it, was still an asset of her bankruptcy estate. But I want to compare that to the Slovak Republic's termination of the mining rights post-petition. The question is whether or not that termination was related to or derivative of the interest in GmbH. And whether or not there was sufficient knowledge of that claim for that to be considered property of a bankruptcy estate that was created 10 years earlier in 2000, a year earlier. For this, I think you have to look to the testimony of Dr. Rozloznik, and specifically his understanding of the meaning of the word dobivanie in the 2002 Mining Act. It was instructive to me to see that discussion among counsel, among Dr. Rozloznik, and even to the extent that the tribunal required Mr. Pekaj to use the Slovak word in the context of his English language questions because of the disagreement or the dispute over exactly what that word means. And it is, by the way, a lovely word. The sound of it on the English here is quite good. Mr. Rozloznik testified that he clearly understood the word and the Mining Act to require mining activities to commence within 3 years and not extraction. That's found at the Day 2 transcript, page 192. Dr. Rozloznik was grilled on cross-examination by the respondent for over 4 hours. No witness testified longer in this proceeding than 81-year-old Dr. Andrei Rozloznik. His testimony was credible. I believe you can look at him, you will see what we call in the United States a man who is the salt of the earth. He is a wonderful human being, and he was credible. The bankruptcy case was closed in March of 2007, and this Mining Act was amended after that point in time. The dispute, Rosman in the meantime was prosecuting its claims arising from termination of the mining rights, which Ms. Jarvis agrees did not violate the automatic stay and agrees those claims were not property of the bankruptcy estate. The dispute for purposes of this arbitration did not crystallize until at least 2012, 5 years after the bankruptcy case was closed, and even longer from the date that the bankruptcy estate was created. I think with regard to assessing whether you have jurisdiction in those circumstances where the crystallization of the dispute was so remote to the creation of the bankruptcy estate, weighs in favor of your concluding that this dispute was not property of the bankruptcy estate, and that the issue, which really in the bankruptcy context was the 1985 company's interest in EuroGas GmbH abandoned or not abandoned when the bankruptcy case was closed, or will it be abandoned here shortly by the bankruptcy court, is really one of standing. Does the 1985 company or its successor, the 2005 company, have standing to assert those claims under the bilateral treaty? Or are they precluded from doing so for failure to schedule the claim or the stock in GmbH in the bankruptcy case. Ms. Jarvis's opinion is that the 1985 company's failure to list this stock interest in GmbH resulted in it remaining in the bankruptcy estate when it was closed. The Snell and Wilmer report comes to a contrary conclusion. David Lita of Snell and Wilmer and Annette Jarvis are outstanding bankruptcy practitioners who both command my highest respect. The Snell and Wilmer report contends that the former trustee actually knew of the stock ownership and intended to abandon it. Ms. Jarvis contends that his knowledge, if he had it, of that asset is irrelevant. I think it's clear that the trustee of the case had to have knowledge of the existence of the GmbH stock when you look at Exhibit C 329. That's the tax return which the bankruptcy trustee prepared on behalf of the 1985 company. The return is a consolidated return, meaning it is prepared for the 1985 company and all of its subsidiaries, and that's normal. Exhibit C 329 is 125 pages long. On pages 90 through 104, you will see the informational return the trustee prepared for EuroGas GmbH as part of the consolidated return. I submit the bankruptcy trustee would not have included an informational return for GmbH if he had no knowledge of it. That being said, the fact remains is you have two outstanding bankruptcy experts coming to different conclusions on whether or not that stock interest in GmbH was abandoned. The good news is that the bankruptcy judge is going to handle that issue for you. He has before him a request by the current trustee to abandon the stock in GmbH. Now we'll stop here. I agree with Dr. Garabi that EuroGas, the 1985 company, did not acquire the interest in Belmont. But to the extent you come to a different conclusion, the trustee's abandonment will also be an abandonment of that stock too. She's not abandoning just the GmbH stock. She's abandoning every asset that would be property of the estate as it relates to the investment under the bilateral treaty. The bankruptcy judge is conducting a hearing on September the 26th. He'll resolve this one way or the other. I think it's important to note, as I mentioned to you in my opening statement, that EuroGas did not want the bankruptcy case reopened. It believed that the interest in GmbH had been abandoned when the bankruptcy case was closed. The Slovak Republic appeared before the bankruptcy court. It was a stranger to the bankruptcy case. By its own admission, Mr. Enway mentioned that they learned of the bankruptcy only from our reply memorial. But they appeared. They filed pleadings joining in the motion to reopen. They wanted the bankruptcy court and the bankruptcy trustee to address this issue for you because, as Mr. Alexander told the bankruptcy court, it would help you. Well, I mentioned that be careful what you ask for, you may get it. The trustee has entered into an agreement with my client to abandon whatever residual interest remains in the investment treaty claim. The Slovak Republic has gone to extraordinary efforts to obstruct that. They purchased a claim. They have filed an objection. They want to, they've engaged in discovery. They have even engaged in conduct this week while we've been here before you by filing more pleadings designed to obstruct and delay the bankruptcy court's ability to entertain the trustee's motion to abandon. But the long and the short of it is the trustee will decide this issue. and its decision will inform you. The Slovak Republic will either win or lose on its obstruction efforts, but you should allow the bankruptcy process to proceed and allow the decisions made there to inform your conclusions with regard to standing. I'd like to address the Utah winding up statute, which is Exhibit R19, Section 1405 of the Utah Corporations Act. That statute provides that a dissolved Utah corporation continues its corporate existence, but may only engage in contracts which further its winding down and liquidation. We discussed this yesterday with Sam Gardner, and particularly as it related to the new Utah court opinion of a few days ago, which holds that all contracts a dissolved corporation enters into are void. His opinion, which I think is the important thing for the court, and not the court, the tribunal to rely on, is that Utah courts will recognize the ability of dissolved corporations to engage in transactions which further their liquidation and winding up, but that transactions by dissolved corporations which do not further their winding up and liquidation will be considered void. That's from the Day 4 transcript at page 98. Ms. Jarvis agreed with Mr. Gardner. Her opinion was that a dissolved corporation would be able to engage in transactions to further its liquidation and winding up, even following a bankruptcy case where the trustee does not administer some of that corporation's assets. And that is found on the Day 4 transcript at pages 73, 75, and 100. That makes sense. What they say makes sense. And this tribunal should give credence to the enactments of the Utah legislature, which has stated that it will allow a dissolved Utah corporation to continue as a corporation and to engage in transactions which further its liquidation and which further its winding up. So what is the result of all of this? The 1985 company's interest in GmbH was either abandoned when the case was originally closed, or it wasn't. And I believe it will be abandoned by the bankruptcy trustee. Obviously, that's to be seen from the proceedings in the bankruptcy court. If the bankruptcy trustee's motion is granted, the legal effect of that abandonment will be that the bankruptcy estate's interest in EuroGas GmbH, title to that will revert to the 1985 company, effective as of May 18, 2004. That is as a matter of law. Mr. Anway suggested that even if the court approves that abandonment, that you should still consider whether you, as this tribunal, in the exercise of your authority, should nevertheless determine that you will not give effect to that retroactive nature of an abandonment under the bankruptcy code. My response to that is, the bankruptcy court is respecting your jurisdiction, and I believe you will do the same, show him the same reciprocity. But going further, I point out again that your decision is to be guided by the purposes and policies behind the treaty, to encourage international investment, including investment by the United States in the Republic of Slovakia, and that not giving respect to the bankruptcy court's retroactive order on the abandonment would not meet the policies of the treaty. I know that that will be your decision, and I know that you will make a decision that is in accordance with your charge as arbitrators under the treaty. With regard to the new Utah case, transactions by the 1985, so the abandonment is retroactive to May 18th, 2004, and under bankruptcy law, the interest in GmbH would be treated as if the bankruptcy had never been filed. Well, at the time the bankruptcy was filed, the debtor was a dissolved corporation. It was beyond its reinstatement period. And so you would need to look at, for jurisdictional purposes, what transactions it could engage in. I submit that the transaction with McAllen would not be one in furtherance of the 1985 company's winding up, and so you would disregard that transaction. And then the only transaction would be whether or not the 2008 transaction pursuant to the joint resolution is one in the nature of winding up and liquidation. And when you take a look at the joint resolution that was entered by the parties and compare that to the testimony of Mr. Gardner and the testimony of Wolfgang Robel. If you take a look at the joint resolution, which is Exhibit C57, you will see clear language that the parties intended that document to effect a merger. They intended that document to be one under which the 1985 company transferred its assets to the 2005 company, and the 2005 company assumed its liabilities. Mr. Robel testified to that effect in the day, I think maybe the day 2 transcript, I'm not sure, on that page, but it's at page 91 of his testimony. Mr. Gardner's opinion is that a dissolved corporation cannot merge, but in their opinion, this is at paragraph 69 of the rebuttal report, Mr. Gardner and Ms. Jarvis state that a transaction may have the same economic effect as a statutory merger, even though it is cast in the form of a non-statutory merger. So in other words, even though there's no statutory merger, or they can't merge under the statute, a dissolved corporation can still enter into a transaction which has the same economic effect as a merger. That is their opinion in their report. I urge you that it doesn't matter whether you consider the joint resolution to be a merger, whether you consider the entities to have engaged in a de facto merger, or whether you consider it to be a transaction in furtherance of liquidation and winding up under Section 1405 of the Utah Corporations Act. The fact remains that the 2005 company took over the assets of the 1985 company and assumed its liabilities. And Mr. Gardner agrees that they had every right to do so. I believe that solves the standing issue. I want to talk about Wolfgang Robel. Many accusations have been thrown at him by the Slovak Republic in its opening statement, in its memorials, and in about every other document they filed with you. The 2005 company was not created in secret. If you take a look at the Ms. Jarvis's testimony, she and I discussed about Utah corporations and the website on the state's page where you can visit, you can determine the existence and status of a corporation. The formation of the corporation was not secret, it was a public record. The Slovak Republic learned of the existence of the 2005 company not by hiring a private investigator, but by going to a public website and reviewing public information. The formation of the 2005 company was not a fraud. As Mr. Robel testified, the prior management had failed to file the annual report, a form, with the state of Utah. Mr. Gardner, in his testimony, testified that a company's forgetting to file a form is not always unusual. That's at the day 4 transcript, page 77. The 1985 company was dissolved not because it was engaging in illegal or fraudulent conduct, but because it failed to file a form. The efforts of Mr. Rebuttal and others in management in forming the 2005 company and entering into the joint venture were the efforts of reasonable people attempting to do the right thing. Mr. Rebuttal testified for 3 hours. You can determine his credibility. I submit to you he's an honorable man and a credible witness, and you should believe him. And that concludes mine. I believe that Mr. Garabi, do you want to go next, or do you want Ms. Wood? Are we out of time completely?
So we make a break. We've heard everything on jurisdiction, and maybe we have questions on jurisdiction before going to the merits.
Mr. President, I just want to make sure that before we break, the presentation of both of you on EuroGas is completed, or is there something to say?
Actually, we had planned to both talk on jurisdiction, but if,
And Ms. Burton, maybe you take yours.
we had planned to both address aspects of jurisdiction, but if we could speak over the break, perhaps we can determine whether that's the best use of the remaining amount of our time. And I was just wondering how much time we have left.
Oh, sorry, that would be for me. You have 45 minutes left of 2 hours.
All right, in light of that, we may make an adjustment and not further address jurisdiction, but we'll speak on the break if we could.
Yes, you can.
Thank you very much.
You guys are, it's around 50, you've used 56 minutes, so you have just over.
Thanks.
But overall, how much?
That's what I'm saying.
Okay.
Oh,
The entire week, you mean?
Yes.
oh, that,
There's a double limit.
Total claimants is 15 hours, 43 minutes. Total respondent is 14 hours, 33 minutes.
But really, I think at this point, it doesn't matter.
So we come back at 10 past 4.
It may be a little later on the part of the tribunal if we're discussing questions to be asked, but be there, please, at 10 past. And we'll try to be there too. Before we ask our questions, what's the position of claimants? Do they want to say something more on jurisdiction?
Mr. Chairman, I think I've distilled the comments I want to make to very few, but I do have a few points that were not addressed by Ms. Burton's comments that I would just like to add before you begin your questioning, if possible.
Okay.
First, just want to point out that it's really beyond debate that 100% of the shares of EuroGas GmbH, which is the investment, were owned by EuroGas at the time that the claim crystallized, which is no sooner than August 1, 2012. At the time the denial of the rights under the treaty occurred on December 21st, 2012, and at the time the demand for arbitration was filed on June 24th, 2015. And those are the only dates that respondent points to in its briefing on this issue as having any relevance to when the ownership of the investment and the bringing of the claim should have coalesced. Additionally, for the reasons that Ms. Burton just stated, EuroGas owned the investment consistently from 1998 all the way through. It owned it from 1998 to 2007, or it was owned by its bankrupt estate. It either acquired it at the end of the bankruptcy for the reasons Ms. Burton articulated, and transferred it to McAllen, or, and then bought all of that stock back from McAllen when it acquired McAllen back. Or that transaction with McAllen was void, and there's no doubt that the transfer of assets and liabilities was a valid and legitimate wind-up activity for EuroGas 1, transferring its assets and liabilities to EuroGas 2 in July of 2008. And then EuroGas has owned it consistently and continuously since then. So for those two reasons, EuroGas has always owned the investment and always had the right to bring the claims under the treaty. Also, respondent did not properly deny the benefits of the treaty to EuroGas because Mr. Ravel never controlled EuroGas. We've talked about that before. Also, EuroGas has substantial business activities in the United States. I provide the tribunal with all of the sites to the information I explained in opening. That has not been rebutted in this proceeding, and as a result, I will not go through it any further because I want to give the time to Mr. Garavi, to Dr. Garavi. And then finally, although I'm sure EuroGas will wait to hear exactly what Dr. Garavi has to say before I say this, EuroGas, in the interest of time, endorses, adopts, and concurs with everything Dr. Garavi will say on the merits of this matter in a moment. Thank you.
Thank you. So now, all questions.
Okay. Well, yes, I have a question for Hamid and one for Mona. So first, Mr. Garawi, I wanted to discuss with you the interpretation of two different documents that might not necessarily coincide. You have said at one point the financial statement have to be read in conjunction with the SPA. And then you said, and my question is, what if there are contradictions between the SPA and, for example, the financial audited statements? You have argued that the clear term of the contract must prevail. And my question is, I wonder if this is so clear. And more precisely, I would like you to discuss whether or not the common concrete behavior of the parties, as stated, for example, in the financial statement, could not modify the agreement of the parties.
Could you point me to which particular, I get what you are asking, which financial statement?
Also, the financial statement we have seen several times. I think it's 100.
Well, I can walk you through the ones.
No, but I don't look at the financial as a general. Concept. I mean, if you want me to be more concrete, you said, for example, that Belmont exercised control, and in one of the financial statements, it's written EuroGas took control. So, if you want an example, but I would like you to deal with this more generally.
More generally, what I want to say in response to that is that what you see in terms of documentation, what you heard is what happened. That's the first message I want to say in response, which is a general statement, that you have everything. Going to the origin of the SPA, it is a réserve de propriété, or a conditional sale, if you want. And then the steps that follow, for me, as I read it, are within that spirit each time. Why? Because documents that, for example, respondent rely on say pending settlement of the guaranteed shares. So for me, it is within the contents of a conditional sale. When I turn to the following one, it also says it's sold, the terms will be realized when payment will be received.
Yeah, but it's not exactly my question. I
Yeah.
said, let's be abstract. Do you
Yeah.
think that the common behavior, common concrete behavior of the parties,
Yes.
which is maybe appears in some document, can modify a contract? No,
Well, generally, I think the contract can be modified
by the concrete behavior of the party.
by a concrete behavior of the parties. You have to tell me under what law are we speaking. I cannot, it's very difficult to answer this question in abstract. But what I can say is that however you look at it, let us look at the concrete behavior of the party. And that's why I say what you see, we're really naked in front of you. We have given you everything there is. It's not just one document, it's everything throughout many, many years. You see a sale, a conditional sale, then you see financial statements. And you have one person who has the character he has, that is pushing, despite the problems he's facing, to try to close. He cannot close. There are correspondence. That's why the term, let's complete, let's try to complete. There is an intention on both parties to complete. You would see my client at one point says, listen, enough is enough. I'm gonna get out of that thing, and tough luck. And that's what ultimately he ends up doing. So I think I cannot answer in general. You have to tell me which law, but I would say ultimately it does not matter because the conduct is consistent with one party trying to close and the other party having more and more reluctance, seeing the other one cannot close, and ultimately retaining not only as it had full ownership, but also keeping the money. Maybe I disappoint you, but that's.
You are not my student anymore. Okay, so now I have a question for Ms. Burton. What do you answer to the respondent's argument that a merger is the contrary of a wine dinner, as it is a way to continue the rights and liability of the former company? What is your answer to that argument?
Certainly, the joint resolution spoke in terms of a continuation of the business, but I think you have to look at the difference between continuing an enterprise in the sense of the business that is being operated and continuing the entity that operates the business. Certainly, the 1985 company ceased operations because all of its assets were assumed by the 2005 company, and the 2005 company assumed all of its liabilities. The shareholders of the 1985 company became shareholders of the 2005 company. So when you think in terms of a business in the sense of talc mining, exploration for gold in Arizona and Idaho, that business continued, but the entity conducting it did not. It ceased conducting operations, and those were assumed by the 2005 company.
It's an interesting distinction. And does it make a difference for you? Does the fact that it was the same shareholders, the same, the same director, the same everything, make a difference to your analysis?
No, they are separate entities under Utah law. If you were to go onto the State of Utah Division of Corporations website and input the name EuroGas, you would find two separate entities, one of which is reflected as having expired because it was dissolved, and the other one appearing to be an active corporation. They have different numbers every time a corporation is created in the state of Utah. It's assigned a unique number by the state of Utah, and each of those entities has a unique number. They have unique taxpayer identification numbers with the Internal Revenue Code and with the state of Utah. So the fact that they have the same, they may not now, but at the time of the creation of the 2005 company, they may have had virtually the same officers, directors, and shareholders, but by law, they're different. By Utah law, they're different entities.
Thank you for the clarification.
Well, I don't think I have a question left, but just to clarify on the issue of the first question for Dr. Garnari, the follow-up as the question posed by Professor Stern. Do I, as to the